All right, going back to the top story we are tracking here on DD India, the implementation of three new criminal laws and their dedication just a short while ago by India's Prime Minister Narendra Modi at a function held in Chandigarh. Joining me is Advocate Sanjay K, Chadha, who practices in the India's top court, the Supreme Court. Mr. Chadha, welcome to DD India. I want us to talk about three broad topics per se. One, the rationale behind these legal reforms, number one. Number two, the implementation or rollout of these laws and the impact on criminal justice system or justice as a whole. Now, to begin with, how would you explain the rationale for these three criminal laws, the Bharatiya Nyaya Sanhita, the Bharatiya Nagarik Suraksha Sanhita and the Bharatiya Sakshi Adhiniyam dealing with the IPC, the CRPC and the Evidence Act?
What was the rationale, if I may say? First, for that, you need to see the history.
Right.
Why and from where these laws have come to us. These laws were made about 100 odd years back. When after 1857's first war of independence, as we read in our history, when the Britishers saw that they are losing their grip, they wanted to have harsh laws. The objective of those laws was to rule the people, rule the people, rule the country.
Right.
How? Whatever harsh laws are, the objective was not to deliver justice. These laws were made about those years, way back 18th century or so. And now after independence, when the independence came, we adopted majority of them in the same manner, except certain amendments, changes which were there. We adopted very little change. And thereafter, now what had happened, there were certain new era has come. We know, modernization, what will happen to the cyber crimes. Many things were absent. The modernization has brought so many new offenses like cyber crime, economic offense being, white collar crimes. All these were missing in the earlier scenario, if I may say. So it was a need of our. Lot of demand was there. People were waiting that we must change the law. There are many offences which were, the Supreme Court, by virtue of their own judgments, have made those offences redundant. Like, for example, adultery. There are so many. 377 is removed. Unnatural relationship that was there earlier. So, in various judgments, Supreme Court has said that why not, if you are punishing a person who is attempted to suicide, let's say, if this is the scenario, a person is attempting to suicide because his scenario is absolutely bad. He is unable to, live. He has decided that he is going to end his life. And if, God forbid, he saves, the punishment will be given because why you have tried to finish your life. So those kind of provisions were removed. Sedition. Look at the sedition point. The law which we have taken from common law, UK, and which is removed from that country, but still we were having it. Supreme Court has directed the honorable central government and all the government machinery to look into it. Committees were made. Law Commission recommended. But it was continuing. We have seen so many. So there can be many examples. Now, why on that basis in 2020 there was a commission, Professor Bajpayee Committee, Criminal Law Reforms Committee was appointed. The objective of which was to just modernize these laws. We have not, we have not removed the entire earlier laws. We have to understand this. The entire earlier laws are not removed, but they are modernized. They have made fit to cater the current society. Now, I put a question to myself. What is the purpose of the law? The purpose of the law is very clearly to cater the needs of the society, cater the needs of the current scenario.
Right.
What with this change, which as your slide is also showing, that these three laws came into force in 1st of July 2024. What we have done with these new changes, like many changes I can say, I have already explained in toto. If I say there are about 20 new offenses are added, 8 earlier offenses were deleted, they are no more an offense, so redundant provisions are removed, and the what you call the scenario which gels with the modern era has come.
As you say, Mr. Chadha, the rationale for these new reforms were, one, to remove the so-called archaic laws from Indian jurisprudence, two, to revisit the colonial era laws, and last but not the least, the focus was firmly on justice as opposed to, say, punishment. Now, talking about the implementation of these reforms, Mr. Chadha, as a practitioner of law yourself, how do you see the way they were implemented or rolled out in the last 5 months in particular?
Well, from 1st July onwards, at night 12 o'clock, these three laws came into force.
Right.
Now, everybody has to keep in mind, whatever were the provisions, whatever is the law which was, whatever are the cases which were going on at 12 o'clock on 1st of July, they will be governed by the earlier laws only, earlier three laws. And from this date, which is the cutoff date, 1st of July 2024 onwards, whatever offenses, whatever criminal act is happening, they will be governed by the new law. Now, these, as you have rightly said, that on time they are rolled. Today we have already passed about 5 months. I feel the working of these laws are very satisfactory.
Right.
Why I say so? Now, under the new law, as you know, if I may say, the most crucial and most important point to me, what I feel is a time limit. Earlier, we know that time was, lot of time go waste in the process, from starting from the FIR, investigation, trial, and so on and so forth. Everywhere, lot of time used to take.
Right.
Courts, investigating agencies, all are pressurized. But under the new law, which is the most dynamic aspect, I think, everything is is to be done within a time frame. If the time frame is not adhered, you have to explain whether you are a judge, whether you are a police officer, whether you are an prosecution or the defense lawyers. You have to explain every delay in writing. You know, that is one. So with that, transparency is being taken into account. And we all know transparency brings the efficiency. And that is what we are expecting, we are seeing. And I think the time to come, as I was saying a day before somewhere, during the next few years, we will see the real change and the quickness in criminal justice delivery system. Both the parties, whether you are a victim, whether you are an accused, both the parties have to really give a huge amount of time. And the other thing which is very important is we have adhered to, as I said, the regime of punishment is now regime of justice.
Indeed. So the focus clearly has shifted away from punishment to the concept of justice. And in addition to what you mentioned, Mr. Chadha, a time limit for disposing of all cases, number one. Number two, transparency. And number three, the repeated adjournments have been discouraged. And last but not the least, we keep hearing about ease of justice as well. There's one other subject I wanted to ask you about towards the end of our discussion, Mr. Chadha, and that is about the use of technology or digital evidence. In this case, all videography, photography and testimonies are to be saved on what is known as the e-evidence server. Talk to us a bit about the use of technology as well in all of this.
I was going into that point. To me, Time was the first important aspect, and second most important aspect is use of technology.
Indeed.
Use of technology has really, scientific investigation has changed the entire realm. You will be surprised. Now, with the help of the technology, our police, our investigating agencies it has become so smooth for them. And that is what where the combination of time and the advanced technologies have really have changed the entire scenario. As I said, and it is now new things are added, like for any offense which is 7 years plus, where every investigation is to be videographed. What does that lead to? Everybody will come to know, both prosecuting agencies as well as the accused side, both will be knowing that everything is done in a transparent manner. You cannot arrest anybody.
Right.
You cannot arrest anybody. The police persons cannot arrest anybody without the prior permission of the senior officers. So this is what, this will not only cater the masses will have more confidence in the system, criminal justice delivery system. Like, there is a provision wherein it is stated that if you are arresting somebody in an offense which is 3 years or less, you can't arrest it without the permission of DCP. If you are arresting somebody who's 60 years plus, ailing, you can't arrest him just on your own. You have to take the permission, written permission of a senior police officer to the grade of DCP. So that is what very important.
Right.
I think these are the rational things which have been adopted.
Indeed.
The modern technology,
Right.
and that's all I think you are
Indeed,
saying.
Mr. Chadha, thank you for breaking it down for our viewers to make it simpler for them to understand as well. Thank you for your time. Much appreciated.